Hello, my name is Amaan Ahmad. I'm a legal intern at LEXIS and Company, and I'm from faculty of London University, pursuing second semester in 3 years LLB. So the topic of my today's video is I will be carrying forward the next topic, which is based on my previous topic, which was the preamble of the Constitution, and the new topic and the today's topic of this video is that the amendments that were made in the preamble of the Indian Constitution uh, after the enforcement. So the first and the foremost question that we talked about after the preamble was that is preamble really a part of the Constitution? This was a very controversial topic, as there has been many discussion about the preamble being part of the Constitution. This question can only be answered by reading only the two case law. So the first example is the Berry Union of India versus Union of India. So Berry case was used to as a reference under Article 143, subclause 1 of the Constitution, which was on the implementation of the Indo-Pakistan Agreement related to Berry Union, and is exchanging the enclaves which were decided for consideration by the bench consisting of 8 judges. So though the court stated the preamble is a key to open the mind of the maker, but it cannot be considered as a part of the Constitution. So the court negated the fact here. So the next case that was the most highlighted case of the Constitution also, if you talk about, and this has brought many changes in many aspects. For some of the changes that we are going to discuss is the preamble. So this case was the Kesavananda Bharati case. So this case created history for the first time. A bench of 13 judges were assembled to hear a writ petition. The court held that the preamble of the Constitution will now be considered a part of the Constitution, and the preamble is not the supreme power or source of any restriction or prohibition, but it plays an important role in the interpretation of statutes and provision of the Constitution. So it can be concluded that preamble is a part of the introductory part of the Constitution. So next, if we talk about is the concept of amendment of the preamble. So after the judgment of Kesavananda Bharati, it was accepted that the preamble is part of the Constitution. So as a part of the Constitution, it can be amended also under Article 368 of the Constitution, but the basic structure of the preamble cannot be amended, as the same goes for the other parts of the Constitution also, because the structure of the Constitution is based on the basic elements of the preamble. As of now, the preamble was the only amendment through the 42nd Act of 1976, which was done through at the time of Indira Gandhi, if I recall correctly. So the 42nd Amendment 1976 brought many changes in the Constitution, but in the preamble was the very first ever to amend the preamble of the Constitution. On December 18, 1976, socialist, secular and integrity were added to the preamble to protect economic justice and eliminate discrimination whatsoever. So though this amendment socialist secular were added between the sovereign and democratic, and the unity of nation was changed to unity and integrity of the nation. So these were some of the minute details that was carried out by the 46 Amendment 1946. So in the next thing that we discuss is the interpretation by the Supreme Court. So the preamble was added to the Constitution after the enactment of the Constitution. In the Berry Union, the Supreme Court held that the preamble is not part of the Constitution, rather it was considered as guiding principle. So, but in the Kesavananda Bharati case, the court changed its previous decision and overturned it, and accepted preamble is now a part of Constitution, which can be amended under Article 368. But in the LIC case of India, Supreme Court continued with its judgment on declaring preamble is again a part of the Constitution. So in the end, the preamble is now considered a part of the Constitution, and there is no such amendment which negates this judgment. So the keywords in the preamble that are the sovereign. So the preamble of the Constitution states that India is a sovereign state. The term sovereign means the independent authority of the state. It means the state has the control on every subject, and no other authority or external power has the control over it. So the legislature of a country has the power to make laws in the country with restriction keeping in mind imposed by the Constitution. So in the case of synthetic chemicals versus state of Uttar Pradesh, the Supreme Court decided the word sovereign means that the state has the authority everything within the restriction given by the Constitution. So the sovereign means supreme or independent. This case helped in differentiating between external sovereign and internal sovereign. So this case proposed that no country have its own constitution unless it is not sovereign. So this was a change that or the interpretation by the Supreme Court in this point of sovereign. So the next point is socialist. So that some socialist was added by the 42nd Amendment Act 1976 during the emergency period. So the term socialist denotes democratic socialism. It means a political economic system that provides social, economic and political justice. So Mrs. Indira Gandhi explained socialism as an equality of opportunity or better life for the people. She said socialism is like a democracy. Everyone has their own set of interpretation, but in India, socialism is a way for the better way of the life. The two cases that I can talk about in socialism is the first version is Excelsior versus Union of India. The Supreme Court found that with the addition of the word socialist, a portal is open to learn the judgment in favor of the nationalism and the state ownership of the industry. But the principle of socialism and social justice cannot ignore the interest of a different section of the society, majorly the private owners. So this was the thing that they also wanted to protect the private owner. So in next is the case of DS Nakara versus Union of India. The court held that the basic purpose of the socialism is to provide a decent standard of life to the people living to the country and protect them from the day they were born till the day they die. These were the major cases that I can talk about in socialism. These are the only two cases, and the next point is that we can talk about is secularism. So the word secular was also added by the 42nd Amendment 1976 during the emergency. The constitution stated that India is a secular state, as the state has no official religion. So if someone asks you if is the Indian constitution biased towards any religion, then you can proudly say that no, India is a secular state and the constitution states that a secular state, as a state has no official religion. The citizens have their own way of life and choose their religion as they like. The state provides full freedom to the people to practice any religion of their choice. The state treats all religions equally with equal respect and cannot discriminate between them. The state has no right interfering with the people with their choice of faith, religion or idol or worship or these points. So important components of secularism are so the right to equality is granted by Article 14 of the Constitution, but the right of against discrimination is protected by Article 15 and 16. So then next is the major Article 19 and 21. They are the bulwark of the Constitution, which protects their right of freedom of expression, speech, and all types of freedoms that are given in Article 19. Next is Article 24 to 28, which protects the religious freedom, and Article next is 44, which is not a fundamental right per se, but it's a fundamental duty of the state to enact uniform civil laws treating all citizens and equally. So it imposes a obligation on the state to make uniform civil laws and treat all the religions on a same parameter. So in the case of SR Mumbai versus Union of India, the 9 judge bench of the Apex Court found the concept of secularism as the basic feature. So the government cannot change it even by the amendment under Article 368. In the case of Bal Patil versus Union of India, the government held that all religion group must be treated equally with equal respect. India is a secular state where people have right to choose the religion, but the state will have no specific religion. In the case of Gopal Krishna Nair versus State of Kerala, the court has stated that the secular state is a different than atheist society, which means the state allows every religion and disrespect no one. This was also reiterated in the Emmanuel case. Sorry, I cannot recall the case right now. Bijoy Emmanuel case. The Bijoy Emmanuel case also. It was also, this point were reiterated in that. So the next point is democratic. The term democratic derived from the Greek word where demos mean people and kratos mean authority, which concluded the government is constructed by the people. So after a long time of colonialism, India had put this democratic word in the constitution. India is a democratic state as the people elect their government at all levels. That means union is state, local, and even to the ground level. Everyone has the right to vote irrespective of their caste, creed, or gender. There is no type of bar in the voting pattern. So in a democratic form of government, every person has direct or indirect share in the administration per se. So in the case of Mohanlal versus Democratic Minister of Raebareli, the court stated that democracy is a so every citizen is equal before the law in a democratic form of government. Then next and the last is the republic. India is a republic form of government as the head of state is elected as not as a hereditary monarch like king or queen. So the term republic is obtained from res publica, that means public property or commonwealth. It means the power to elect the head of the state for a fixed term lies within the people. So in conclusion, the word republic shows a government where the head of state is elected by the people rather than by right. So there is no hereditary position in the government, and the constitutional bars it in the preamble. So there is no case law as which treats this point as a basic structure, but if any case will arise, I am sure the courts will treat this as a basic structure. So guys, before concluding this video, I'm going to tell that please remember this video does not violate any guidelines of the Bar Council of India and does not solicit or promote any of the advertisement. The sole purpose is educational. And guys, please subscribe to the channel if you haven't already to see more of this content in future, and I'll be coming with the next video soon. And please provide a feedback to this video and put any question if you have in the comment box so that I can reply it as soon as possible. Thank you very much for watching this video. Thank you.